Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon. My name is Josh Pettengill. I want to thank everybody again for joining us today for this Third Thursday webinar. And today I'm going to be discussing liability Medicare set-asides and Medicare Advantage plans. This topic of Medicare Advantage plans has gotten a lot of attention recently, and rightfully so, because more than 1/3 of the Medicare beneficiary population are receiving Medicare Advantage plans. Just by way of quick background, I'm one of the principals of Synergy Settlement Services and also oversee our Medicare Secondary Payer Unit, and have had the privilege of handling thousands upon thousands of cases involving Medicare Advantage plans and injury victims. So here's our plan for today. Talk a few minutes briefly about Medicare Basics, and then we're going to go through traditional Medicare plans and eligibility for those type of plans. And then we're also going to talk about CMS's guidance on the issues, which is very important, and what the perspective is from Medicare for plaintiffs who have Medicare Advantage plans. And I'd encourage you to hang in there for these real-world case examples. As far as practical application, these are going to be the discussions that you need to hear, and these are going to be talking about cases that we get on a regular basis from you as trial attorneys. Best practices, of course, and then at the end, we're going to talk about Medicare set-aside trust. So let's start from the top. And I don't intend for this to be a full Medicare overview, but hang with me as we briefly discuss the origin of the Medicare Secondary Payer Act. So from Medicare's standpoint, there's something called the Medicare Secondary Payer Act, and this is the only law that exists on these issues. This was passed way back in 1981, and this law has not changed at all over the last 35 years. And the long and the short of it says that anytime there's workers' comp, third-party liability, or no-fault insurance available, Medicare doesn't want to be stuck paying the tab for something. So in other words, if you as a trial attorney are settling a case for someone, and as part of that settlement, there involves monies to cover future medical expenses related to the accident, Medicare doesn't want to pay for that. It's almost like double dipping from their standpoint. And this is what they always cite as the basis for their ability to potentially deny something in the future as it relates to your plaintiff. So if Medicare knows that your client is receiving compensation for future medical care, they don't want to be stuck paying for that first. They want some money to be spent down and spent appropriately before they would potentially kick in. And every announcement that Medicare has made on liability issues and liability Medicare set-aside, they always start out citing the Medicare Secondary Payer Act as their basis for their ability to potentially deny claims in the future. This slide really sums up the obligations of the settlement parties involved on liability cases. So as it relates to the conditional payments and past interest, everyone has skin in the game. Every settlement party has skin in the game and must ensure that the conditional payments are satisfied. But as it relates to protecting Medicare's future interests, this is a plaintiff issue, and Medicare has made that very clear, going back to the CMS policy memo saying it's up to plaintiff's counsel to decide whether or not future medicals are funded, and if they are, whether or not the Medicare trust fund should be protected. So there's a big disconnect in the marketplace as far as the rights and responsibilities of each party involved in a liability case. We frequently receive phone calls from plaintiff attorneys, our clients, saying the defense is making it their business, saying that they have responsibility and they have skin in the game as it relates to doing a Medicare set-aside. Nothing could be further from the truth. From Medicare's standpoint, they've gone on record to say it is the defendant's job to report the case when there's a Medicare beneficiary. So if you haven't started to get those requests yet, you're going to start to receive these requests by the defendant and by the insurance companies asking for information about your client, the plaintiff, the injury victim. They're so worried about not reporting the case in a timely fashion that they're being overly aggressive in how they try to report these cases. And in doing so, also create sometimes Medicare set-aside issues for you as a plaintiff attorney. And oftentimes those issues are coming up towards the end of the case, where that's very unexpected. But the takeaway here for this slide is everyone has skin in the game as it relates to the conditional payments and the past interest. The defendant's job is to report the case only as it relates to futures, and it's up to the plaintiff's counsel to address the Medicare set-aside issue. So your responsibility as the trial attorney is to simply educate your clients on the potential implications of doing a Medicare set-aside or not doing a Medicare set-aside. In other words, you can't force your client to do a Medicare set-aside, but you can have the discussion that, look, if you're going to have to treat in the future, you should properly consider Medicare's future interests, and Medicare's preferred way of doing that is a Medicare set-aside account. So our key takeaways for this talk today: you're never required to do a Medicare set-aside. It's almost like a special needs trust when you have a client that's on Medicaid benefits. You can't force them and force their hand to do a special needs trust to preserve their Medicaid eligibility, but you can offer them the option of doing a special needs trust. And you can also drive that ship as far as them having understanding of why they should consider a special needs trust, or in our instance, we're talking about Medicare set-asides. And today I'm going to briefly talk about alternatives to doing a traditional Medicare set-aside. There are ways to avoid doing a traditional Medicare set-aside account without shifting the burden to Medicare to pay for things. So your key takeaway here in this slide is this is your litmus test for when you're auditing your files, what you need to look for. If you have a client that's, number one, Medicare eligible, number two, there's potential for future treatment as it relates to the accident, or there's future medicals that were claimed as part of the accident, and number three, is there actually some money left over that fund future medicals? And if the answer is yes to those three questions, you want to certainly consider doing a Medicare set-aside, and certainly want to recommend having that discussion to your client and bringing experts to explain that to your client. And CMS has made it clear that the Medicare set-aside is the preferred method of protecting the trust fund. So the Medicare trust fund has been losing a lot of money. And as those of you know who've been watching the news recently or reading the newspapers, you've seen or heard that the Medicare trust fund is losing a lot of money. And one of the ways CMS is trying to preserve the Medicare trust fund is by way of these personal injury settlements, believe it or not. And over the last 10 years, going back, we've seen Medicare hint and talk about establishing formal guidelines for liability cases, but they have not done so. Now, they've since set a hard timeline of 18 months going back to April 2018 for when they anticipate rolling out formal guidelines for Medicare set-asides on liability cases. So that's why it's important now as trial attorneys to get ahead of the issue and start developing internal practices for your own law firm now, before the panic ensues when Medicare does make the announcement and establishes formal guidelines. You don't want to be caught behind the eight ball. So going forward, what I anticipate happening, and we haven't seen this yet, is that Medicare is going to start denying benefits for plaintiffs post-settlement. So in the old days when you settled a case, you never had to worry about Medicare not paying for something for your client. You always knew Medicare was going to pick up for your clients after the fact. Assuming the conditional payments were satisfied and Medicare closed their file on the past interest, you never had to worry about Medicare denying something in the future. Unfortunately, that's going to be changed, I think, going forward. And we have not yet started to see that in the marketplace, practically speaking. And again, we're blessed to handle thousands upon thousands of these cases every single year. And the number of denials, of upticks and denials that we've seen has not been anything. So just to give you some perspective, over the last 10 years for both workers' comp and personal injury liability cases, the number of denials that we've seen actually happen is probably less than 25 cases, which is a very low number. But again, I anticipate that's going to change vastly going forward. Real quickly, just by definition, what is a Medicare set-aside? A Medicare set-aside is exactly what it sounds like. It's just money that's literally carved out and set aside in a separate interest-bearing account to be earmarked for things that ordinarily Medicare would pay for. So the best way to look at a Medicare set-aside is simply like a deductible. So let's say there's a $5,000 Medicare set-aside. That's a good faith number that protects Medicare's interests. You've hired an expert or come up with a number that assumes $5,000 is the number to protect Medicare's interests. Once that $5,000 has been spent down on accident-related care and spent appropriately, Medicare will then kick in and start to pay again. Now, meanwhile, Medicare is going to pay all day, every day for things not related to the accident, of course. We're only talking about things related to the accident and what was claimed as part of a settlement. And the purpose of doing a Medicare set-aside is to protect everybody involved, starting with you as the trial attorney and ending with the injury victim as the plaintiff. Because ultimately, the worst case that could happen is your injury victim, your plaintiff, Mr. John Doe, goes to get a surgery 6 months after the fact, and Medicare denies that. And guess what? They start denying things indefinitely. And what could happen is the plaintiff could come back to you as a trial attorney and say, why didn't you have this discussion with me? Now my benefits are getting denied. We have seen that happen. We've had scenarios where trial attorneys have called us and said, Josh, I had settled cases over the past couple of years, and now my client's getting denied treatment for something, and they're coming back after me. Now, there's no case law out there that exists where that's actually gone through and run the gamut, but we are receiving those phone calls and have received those phone calls and had to bail out attorneys in those situations several times. You don't want to get yourself caught in that situation. So what are the Medicare Basics? The good news about Medicare is that it's not income or asset sensitive, whereas with Medicaid, if you have a certain amount of dollars or assets, you will not qualify for Medicaid entitlement. Whereas with Medicare, there can be a $100 million settlement and your client will still be eligible for Medicare benefits. It's funded by FICA. Typically, they have to earn enough quarters and be disabled if they want to get into Medicare earlier. And I'll talk a little bit more about that as we go through this and how you can have clients that are below the age of 65 and still qualify for Medicare. And there are also all instances where even if your client has not worked enough quarters, they can buy in to Medicare still. So how can your client be eligible for Medicare? Number one, age 65, which we all know. If they're receiving Social Security disability benefits for a period of 24 months, after the waiting period of 6 months, they become eligible for Medicare. So we have a lot of clients that are under the age of 65 with a severe disability. And with disability benefits, as many of you all know, sometimes it can take at least 2 or 3 times to become eligible for disability benefits. But ultimately, that plaintiff can become eligible for Medicare benefits by way of Social Security disability. End-stage renal disease, we've had a lot of these cases here recently, very tragic cases where you automatically qualify for Medicare. Lou Gehrig's disease, and there are situations where you may have a minor involved where they're disabled and they had a deceased parent or disabled parent where that minor child can also become eligible for Medicare. Here are your basics of coverage. It's important to just note these very briefly. Part A, hospital insurance, covers inpatient hospital care and skilled nursing facilities. Part B, medical insurance, helps cover physician and other supplier item services as well as outpatient care, and oftentimes covers things that Part A doesn't. And Part A and Part B are the most common forms of Medicare health coverage. Oftentimes, folks who are on Part A and Part B will opt into what's called a Part D, which is a drug plan. And that's a separate policy in itself. But today, our focus really is going to be on Part C Medicare Advantage plans. They don't get a lot of attention as much as they should be in a positive way because there are so many positives of having a Medicare Advantage plan versus traditional Medicare. Unfortunately, traditional Medicare is a very broken system right now and has a lot of issues on its own, whereas Medicare Advantage plans, all those plans are provided through private health insurance companies, which are for-profit centers. So here are the statistics of Medicare Advantage enrollees. and Medicare overall beneficiaries. And as you can see in this slide, over 19% of the population is now enrolled in Medicare. And you can see every single year since 2003, that number has gone up. And that's only going to continue to go up as life expectancy increases. Ever since they started taking the Census Bureau and analyzing life statistics data over the last 50 years, that number has increased every single time as far as life expectancy. People are living longer, and that therefore health insurance is costing more money. But as you can see in this slide as well, the percentage of Medicare Advantage plan beneficiaries versus traditional Medicare. Right now, as it stands today, the number is 33%. What that means, practically speaking, for you as a trial attorney, that if you have 100 clients who are on Medicare, 33 of those clients are likelihood to be on a Medicare Advantage plan. And God bless our clients, most of them don't even know what type of coverage they're receiving. So it's important for you from the onset as the trial attorney to request that information, which I know a lot of you are doing. But there's also a form that you can get, and we can provide this to you if you want to request it after the fact, where you as a trial attorney can go down to the local Social Security office on behalf of your client, or that injury victim themselves can go down to their local Social Security office in about 15 minutes, find out exactly what benefits they're eligible to receive, whether it be Social Security disability, Medicare, Medicaid. They can find all that information out. Because I can't tell you how many times that I've been in mediation, we're sitting around a table, and all of a sudden a plaintiff says, oh, I got my Medicare card last week, or oh, I got a Medicare Advantage plan last week and from United Healthcare, Cigna, Blue Cross Blue Shield. Oh, by the way, I used it when I went to the doctor. Now all of a sudden you thought you had a client that didn't have Medicare, wasn't eligible for Medicare benefits, and now we're scrambling to address the Medicare set-aside issue. You don't want to be in that situation. So the requirements for Medicare Advantage eligibility are pretty small. The client has to be enrolled in original Medicare, Part A and Part B. They must live in the service area of a Medicare Advantage insurance provider, and they can't have end-stage renal disease. So in other words, anyone that's eligible for regular Medicare can be eligible for Medicare Advantage plan, assuming that they don't have end-stage renal disease. So these Medicare Advantage plans, they are offered extensively throughout the country in every state. And these plans, although they change frequently, they're always available to your clients. And I encourage my clients all the time, whenever they can, to opt into a Medicare Advantage plan for a number of reasons, which we'll discuss. But a Medicare Advantage plan is simply private health insurance when it boils down to it. And the way these Medicare Advantage plans work, they have contracts with Medicare. And Medicare pays them a set fee per year to handle these claims. And as it stands today, I have never seen a Medicare Advantage plan deny something for a plaintiff post-settlement. And that's a span of tens of thousands of cases. Practically speaking, it hasn't happened. Now, from Medicare's standpoint, what they've told us is that they've started to share what's called the common working file with their Medicare Advantage plan providers. The common working file, for those of you that don't know, is a file that tracks Medicare entitlement, but also tracks Section 111 reporting data. Going back to that slide of whose responsibility is it to report the case, that's the defendant's responsibility. So what happens is when that defendant is reporting that claim to Medicare, all of that information about that plaintiff goes into their file, including ICD codes and body parts and compensability, settlement information. So Medicare has spent a lot of money developing that tracking mechanism, which is Section 111 reporting, to make sure that they have accurate information to potentially deny something down the road if they think it's related to the accident. So the takeaway there is allegedly Medicare is now sharing this file with Medicare Advantage plan providers, which then gives them the ability to potentially deny something. It has not happened yet. It's not to say it won't happen. What's nice about a Medicare Advantage plan is that instead of having to have a Part A or Part B or Part D or three different types of plans per se, they can have one plan that covers everything and essentially replaces Part A, Part B and Part D. Now, some of these Medicare Advantage plans are offered one-offs as supplemental plans. So you may have a client that's on traditional Medicare Part A and Part B, but they also have a supplemental plan, which may cover some copays or deductibles, or may cover some drugs. Typically, and most frequently, a Medicare Advantage supplemental plan is usually a drug plan. But there are all-encompassing Medicare Part C plans, and that is what I encourage my clients to enroll in anytime they can. What's nice about Part C plans is that they're also cheaper from a premium standpoint than traditional Medicare. So on average, in 2018, the average premiums for Part B, traditional Medicare, were $134 a month. Now, looking at the same data for Medicare Advantage plans, on average, the premiums were only $70 a month. And in fact, 81% of Medicare Advantage plan beneficiaries pay nothing. It's called a pay zero premium plan. And insurance companies are able to offer that because they're getting compensated back from traditional Medicare and CMS. So, like traditional Medicare, those premiums can be set up and paid for directly out of their Social Security checks, but it does not happen automatically, whereas with Medicare, those premiums are paid, set up automatically, and deducted from Social Security benefits. Now, what is CMS's position on Part C plans? This slide here is taken directly from what's called the Workers' Compensation Medicare Set-Aside Reference Guide. This is published every couple years directly for Medicare, and this is really their position. It says an MSA is still recommended when you have health coverage through other private health insurance, the VA, or Medicare Advantage Part C plans. Other coverage could be canceled, or they could elect not to use such a plan. An MSA is a primary to Medicare Advantage and must be exhausted for using Part C benefits for your injury. So Medicare says in their guidebook, look, we don't care if you've got other private health insurance. We don't care if you have a Medicare Advantage plan, which is, again, almost the exact same thing as private health insurance or any form of health insurance, because you know what? You could ultimately lose those benefits, and guess what? We're back to being the primary payer for those injuries. So in the real world, those providers and plans of Part C coverage have continued to pay. And in the real world, private health insurance companies are going to pay for your client's coverage going forward. I tell clients it's a blessing when they have private health insurance. They can use that coverage instead of having to rely on a Medicare set-aside plan. They can save those dollars because they have the added benefit of a private health insurance plan. So from a risk tolerance standpoint, let's assume for a second that your client does have a Medicare Advantage plan. Let's call it a Blue Cross Blue Shield plan that they've been involved in, enrolled in for a number of years. They like the coverage. They don't plan on getting out of that coverage. And let's say you're settling a case for them where they're going to have to treat in the future. In those situations, oftentimes we still would recommend a Medicare set-aside be done based on what Medicare has told us. So there are ways to be compliant with the Medicare secondary payer statute while getting the benefit of the Medicare Advantage plan. So oftentimes in those situations, from a practical standpoint, even though Medicare said this in their guidebook, that, you know, the Part C plans and private health insurance plans shouldn't be billed, we say, look, the reality is Medicare is not going to pay for those things as long as there's another form of health insurance. But at the same time, if you do lose that coverage, we want to make sure that you have an insurance policy. And that insurance policy can be the Medicare set-aside account. So oftentimes in these situations, what will happen is we'll do a Medicare set-aside analysis, come up with the lowest possible number that we can justify and defend to make sure the client's protected, and the client will set that account up, meaning they'll go down to their local bank and open up a separate interest-bearing account, and they'll have that account established. Now, we've already talked about how a Medicare set-aside is never required by any law or by any statute. So them establishing the account itself is the first vital step in compliance. Now, if by chance a Medicare Advantage plan or private health insurance plan happens to deny coverage for that plaintiff, they still have the Medicare set-aside in place, which caps them of what they could potentially have to pay back to earmark towards Medicare. So the benefit of doing a Medicare set-aside account, whether or not your client's on any other forms of health insurance is to cap their exposure of what they would potentially have to pay towards Medicare. So when a Medicare set-aside is done, it's simply a good faith estimate of future care and what needs to be set aside. So it's based on all the data that's available at the time of the settlement. There are other components that come into play, such as the full value of the case, which I'll talk about, versus what the client's going to be recovering in their pocket. But all these things come into play and interplay in how we come up with the lowest possible number. Now, oftentimes in these situations, these accounts will be set up. They'll continue to use private health insurance or Medicare Advantage plans. But oh, by the way, if Medicare comes back and says, oh, we shouldn't have paid this, or the Medicare Advantage plan comes back and says, oh, we shouldn't have paid this, well, guess what? They've got money set aside that in the interim is just simply earning interest for them as a savings account, which is a good lead-in for these case examples. We get this call probably 15 times a week where we have a plaintiff who's severely injured and is going to have to treat in the future. They're going to be recovering monies towards future medical care, and they're on private health insurance, whether it be through a spouse or some other way through a former employer, but they have private health insurance at the time of the settlement. I just went through this with a case in Chicago where we had a severely injured plaintiff, $18 million settlement, where the plaintiff is going to be receiving their Medicare card potentially 9 months down the road from the time of the settlement. But in the interim, they had no coverage. So they are now getting set up with a private health insurance plan to cover them until they become eligible for Medicare. And what's nice about the plan that they've enrolled in is that the provider also offers Medicare Advantage plans. And potentially it's going to be an easy transition, or not a transition at all for them when they become eligible for Medicare. Instead of opting into traditional Medicare, they're going to opt into a Part C Medicare Advantage plan. So in these situations, it really comes down to risk tolerance. So we'll oftentimes be brought into a case, and I'm not talking about the large 8-figure, 9-figure, 7-figure settlements. I'm talking about the bread and butter cases. I'm talking about 6-figure settlements, even large 6-figure settlements, where they have this plaintiff who's so close to eligibility for Medicare, but they don't yet have a Medicare number. So in these situations, we'll explain to the plaintiff, look, in all likelihood, there is a very slim possibility that Medicare is going to be aware of your settlement because you don't have a Medicare number at the time of your settlement. Now, there have been instances, in full disclosure, where we've seen plaintiffs pop up in the system as Medicare eligible even before they receive their Medicare card. And typically it's in situations where there's been a 7-month or 8-month window or less where they're going to be receiving their Medicare card, where when the defendant goes to do a query for that plaintiff, they come up as Medicare eligible and they come up with a Medicare number. Those are very, very rare. And I've asked John Albert, who is one of the head honchos at CMS and a director at CMS, about this situation, and he said it's almost impossible for that to happen, but on rare cases it does happen. And of course, we've seen that happen. So what that means, practically speaking, is that there may be situations where you have a client that, even though they don't have a Medicare number, they still get pinged in the system as someone who does, meaning Medicare could have access to that case information, which means they could potentially deny something down the road. And again, the way we explain this to clients is, look, in all likelihood, Medicare is going to continue to pay for your coverage down the road and pay for your benefits and pay for these things for your accident post-settlement, but we still will recommend you set aside something. That way you're protected. If Medicare ever does come back, you can say, look, I set aside some money, and here's what I set aside and spent down to protect your interests. It's really just an insurance policy in these situations. But again, ultimately, you can't make your client do a Medicare set-aside here. We oftentimes see clients who are receiving VA benefits as well are enrolled in traditional Medicare. So going back to Medicare's position on it, you just saw what they said. They said, we don't care if you got VA benefits. We still think you need to do a Medicare set-aside. And oh, by the way, you should spend that money first. That money being the Medicare set-aside funds. So practically speaking, our clients who have VA benefits, as long as they treat at a VA hospital, they're never going to use that money from the Medicare set-aside account. More importantly, there's not a burden shift to Medicare. Okay, that's what it boils down to. When you're settling your case, is there a potential shift in burden to Medicare to pay for that person's care in the future? So Medicare, unfortunately, doesn't deal in the real world a lot of times with these issues. And they're doing everything possible, of course, to make sure the Medicare trust fund is protected, and that's why they have to say these things. But again, in these situations, we tell our clients, look, as long as you're treating with VA, there's not going to be a shift to Medicare to pay. But if, God forbid, you need emergency care or have to go get treatment from another hospital or another provider that's a non-VA provider, there is a potential shift in burden to Medicare to pay. So in these situations, we'll do a consultation with the client and let them make a decision again and say, look, this is your decision to make if you want to set aside money or not. And if they don't want to set aside money, we'll prepare a very comprehensive waiver that says you as the trial attorney recommended they address the issue and they decide on their own not to do a Medicare set-aside. But if they decide ultimately to do a Medicare set-aside, then obviously we come up with the lowest possible number that we can justify and defend as it relates to Medicare. So Medicare Advantage plans. Again, if you have a client that's on United Healthcare, Cigna, Blue Cross Blue Shield, or Humana type plan, Part C plan that's all encompassing, practically speaking, what we've seen is Medicare has continued to pay. But from Medicare's standpoint, they still want you to do a set aside. So best practices in these situations would still be to set aside money for someone who has a Medicare Advantage plan. Now, that doesn't mean it's a formal analysis that you've engaged us to prepare a formal report and done the full comprehensive review of the medical records. At the end of the day, something is better than nothing. Meaning, let's say you have a $50,000 slip and fall case. It's asinine to pay us money to do a full review when you could ask the medical doctor or treating physician what the future costs are going to be, or just have a good faith estimate of what those numbers are going to be and recommend your client set that aside. It's still better than doing nothing. It's still an informal Medicare set aside. It could be a self-administered plan where if Medicare ever does audit that file by chance, which in that scenario is highly unlikely as it stands today, but if they did, there would still be money set aside that addressed and considered Medicare's future interests. So best practices with these Medicare Advantage plans, these Medicare Advantage plaintiffs, is to still carve out a Medicare set aside, okay? But meanwhile, they could still use that coverage, whether it be through private health insurance or through some other entity. The plan always is the same. As long as they're paying, let's allow them to continue to pay. They've done nothing wrong, and yet at the same time, they still have money set aside and earmarked to consider Medicare's interests. Now, from Medicare's standpoint, they ideally want the money to be spent immediately after those funds are set aside. I can tell you practically, this is not conceivable. We've had clients that have tried to pay their Medicare Advantage plans directly and try to pay their providers and their doctors directly when they've had Medicare Advantage plans, and they don't accept it. They don't do it. They're just not aware of what a Medicare set-aside is. Now, there's been some announcements over the past 18 months that CMS has sent directly to providers all across the country saying, look, this is what a Medicare set-aside is. You should accept this money. But hospitals, providers, doctors, they're just so used to billing Medicare that oftentimes they just continue to bill that plan, bill that health insurance plan, or bill that Medicare directly, that the plaintiff has no control over that. But still, you as the trial attorney, your business is to make sure that your plaintiff is protected. And by setting aside money, there's no doubt that Medicare's interests will be protected. And the benefit of engaging a firm like ours, if we're going to do a Medicare set-aside, is that liability is shifted upon us as the experts who comes up with that number that we ultimately recommend the client set aside. Assuming those funds are spent appropriately, Medicare should always pick up. Now, there are alternatives to doing a traditional Medicare set-aside. Plaintiff can use other health insurance. I just talked at length about this issue. There are certain forms of health insurance. There are certain fringe benefits. There are certain retirement benefits that oftentimes allow for life insurance or health insurance, benefits for life for that individual once they retire even. So from a real world standpoint, that person is not going to lose their coverage in those situations. And there's not going to be a shift in burden to Medicare to pay. Now, for traditional health insurance, that not likely is the case, because at some point they're going to become eligible for Medicare, and they have the option of opting into a Medicare or Medicare Advantage plan. But from a real-world standpoint, again, the way we explain it to clients is, look, as long as you have health insurance, you have nothing to worry about. But if that health insurance does go away, this does become a concern for you, potentially, that Medicare could deny something down the road. We've had plaintiffs that want to pay out of pocket as they go for treatment. So instead of setting up a traditional Medicare set-aside account, separate account, which they should be doing, if they're going to do a Medicare set-aside, they say, you know what, Josh, I'm just going to pay as I go and tell my doctors I'm paying for this out of pocket, which is certainly a viable option. The problem with that is that it can get super expensive. So when we're doing a formal Medicare set-aside analysis, again, we're conducting an analysis based on all the information that's available today. It's a good faith estimate coming up with the lowest number possible. Whereas if that plaintiff decides to ultimately not set aside funds, just pay as they go, it could end up costing them a lot more money out of pocket rather than they had just set up a good faith number on the front end. So maybe instead of setting aside $5,000 on the front end, it may end up costing them $10,000 or $15,000 out of pocket if their condition gets worse for them. But it is a viable option to not doing a traditional Medicare set aside if they want to take on that risk. Medical savings accounts, those are also interesting accounts that only certain people are eligible to receive, but that is an option to not doing a Medicare set aside. A settlement preservation trust. My partner, Jason Lazarus, was in a horrific accident a couple years ago, and as part of the terms of his settlement, he ended up setting up a trust that was earmarked specifically to pay for his accident-related care. And we have that happen quite often where a client will set up a trust, which is great for a number of reasons as a standalone option for anything, just protection of those funds and growth of those funds, but it's earmarked to pay for ongoing health care for that person. And a structured settlement is also a very nice way, a nice alternative to doing a traditional Medicare set-aside. Whereas, I'll give you an example of a case that we had in California where it was a quadriplegic that was on Medicare and clearly had a significant amount of future care going forward. And instead of doing a formal set-aside analysis, which the attorney did engage us to come up with a number, it was a very large number that we recommended the client set aside compared to what the value of the case, full value of the case was. So we ultimately were able to reduce that number to come up with a good faith number that we recommended they set aside. Now the client said, look, you know what, I don't want to set aside that amount, but I am going to set up a structured settlement to cover my ongoing needs. And if I need to pay for anything that's related to the accident, I'm just going to use my structured settlement monies to cover that. And oftentimes we'll actually set up a separate structured settlement stream to fund future medical care versus just traditional living expenses. So definitely a viable option. It should also be noted that even if a client is setting up a traditional Medicare set-aside account, one of the ways that they can cut down the cost of that is that CMS and Medicare allows that Medicare set-aside obligation to be funded with a structured settlement. So instead of them setting aside a lump sum amount, for example, $100,000, they can purchase a structured settlement for maybe $50,000 or $60,000 that will pay out that $100,000 over that person's lifetime. And the present value cost is much cheaper, obviously, for that. But number two, more importantly, is that instead of that client having to exhaust that full $100,000, which in principle would last their entire lifetime and life expectancy, they would only have to exhaust in any given year that amount of money that's in the account. So let's say there's an annuity that's paying $5,000 per year. They would only have to spend down that $5,000 before Medicare would then kick in and pay again. It's a huge benefit. So this is what you have to ask yourself when you're settling a case. By settling this case, am I shifting the burden to pay for accident-related care? You have to think long and hard about that question, because the answer is yes, you certainly want to consider doing a Medicare set-aside. So as it relates to compliance 2019, we've laid the foundation for you here. You got to start early identifying Medicare beneficiaries to avoid especially unwanted delays in settlement. or potential issues with Medicare down the road. We see it too often and so frequently where this Medicare set-aside issue becomes an issue when it didn't have to be. What I mean by that is you're having these discussions with your clients already about conditional payments and that they may have to and are going to have to pay back Medicare. So when you're having those discussions with your client, it's important to introduce the concept of a Medicare set-aside. It's important also to let them know that, look, you will be bringing experts to advise them potentially, and that those are going to be costs that they're going to have to bear. That's case costs, just like a life care planner or economist would be. You got to control the process from start to finish. What I don't want to happen, what I've seen happen in workers' comp, is that this process is completely driven by the insurance industry, right? They're the ones that engage their own experts to do a Medicare set-aside. They're the ones trying to call the shots and dictate how the money is going to go to or when it's going to be cut. If there's no Medicare set-aside, you have to jump on the issue early on and establish to the other side, look, we're going to identify whether or not my client's on Medicare benefits, and we're going to identify whether or not we're going to do a Medicare set-aside. And, oh, by the way, if my client is on Medicare, we're also going to control the conditional payments and make sure those are taken care of. And, of course, we'll indemnify the defendant. That's not a problem, but you got to control that process if you want to settle your cases in a timely fashion and avoid any potential liability in the future. And you can't rely on the other opposing side's experts as relates to these issues. You would never rely on an opposing side's life care planner or economist report. So why would you do the same as it relates to a Medicare set-aside account? There is a fixed methodology that Medicare requires when preparing a Medicare set-aside, but at the same time, this is a very gray area. There's no liability reference guidebook like there is in workers' comp. So we have some flexibility on almost every single case to reduce that Medicare set-aside number. So what I'm seeing happen on a daily basis is that case settles for agreed upon amount. All of a sudden at the 11th hour, you as the trial attorney, you as the plaintiff attorney, get a release, a draft of that release, and in that release, it's imposing a Medicare set-aside on your client, or it's trying to impose language on your client that handcuffs their ability potentially to maybe apply for Social Security disability, maybe spend some of those settlement dollars that you've worked so hard to get for that client. And that's why you have to control it and have your own expert who can say, look, here's the proper number. This just came up on another case in Louisiana where case settled and the defendant threw out a number that they thought was acceptable and that what the plaintiff should set aside without any basis. They said $1 million was the number that should be set aside. And we said, that's not ever going to happen. We did our own analysis and came up with a number around $240,000. And when we were able to fund that number with a structured settlement, it came down to less than $160,000. So they being the defendant recommending $1 million be set aside, we did the full-blown analysis, reviewed all the medical records, did a comprehensive review of everything, and the ultimate present value cost was about 88% less ultimately than what they had recommended. You've got to have your own experts on these issues. You got to educate your clients on potential risks of not properly addressing Medicare's interests. The worst thing that can happen, again, is you don't talk about the issues, and your client gets dinged down the future and their benefits get cut off indefinitely. And they come knocking on your door saying, hey, wait a minute, why don't you tell me about this issue? It is a very far-fetched risk as it stands today, but it's not so far-fetched given what Medicare has told us going forward in the future. It's also vital to communicate with opposing counsel on what the correct data and ICD codes gets reported by the defendant. As it stands, you have no idea what the defendant is reporting to Medicare. And 97% of what Medicare relies on, CMS relies on, comes directly from the reporting requirement. That's a fact, directly from Medicare's mouth. So what you don't want to happen is the wrong ICD codes get reported, and next thing you know, your client is going to treat for their knee, and the knee never was part of an accident or claim, and that gets denied because the wrong ICD code was reported. So in those situations, please feel free to call us anytime you have questions about the proper ICD codes. You can actually take it a step further and put the proper ICD codes in the release language itself. So that way, if there's ever a question mark down the road, the proof is in the pudding. It's in the release saying, look, clearly stated, here's what was compensable. Here are the ICD codes. Best way, best practices. go on the offensive for these Medicare Advantage Part C liens and potential MSA issues. So when you identify those Part C plans and Part C plaintiffs, you want to make sure that you also go after those liens. We didn't talk about conditional payments or liens today, but with a Part C lien, Medicare, the BCRC, they will not give you that information because they don't have access to that information. Meaning, unlike traditional Medicare where you can go on the portal, you can communicate directly with Medicare, they'll tell you what their final number is, they'll tell you what you owe them, they'll give you their final demand. With a Part C lien, you have to proactively go out there and find out what that lien is and whether or not it exists. And there's a lot of case law out there that exists on the issue of Part C plans. And Humana has really been the one driving that ship. But if you Google Part C plans and conditional payments lawsuits, a number of things will pop up. And arguably, these Part C plans have the same rights of recovery as traditional Medicare plans. So it's important for you to identify those liens. And if you know for a fact that there's some massive liens out there and someone paid for that coverage, there's a good chance that that was a Medicare Advantage plan. And certainly we can assist with those liens as well as part of what we do at Synergy to make sure that your client gets the most money and that you as a trial attorney are protected. But ultimately, it comes down to documenting your files to what was done or not done on both conditional payments and the Medicare set-aside issue. But like I said, you can't force your clients to do a Medicare set-aside, but you can educate them and bring in the appropriate experts to talk to them about the issues. And then if they decide not to do anything, you document your file and say, look, the client was explained their options, they were given the opportunity to do this, and they elected on their own not to do anything. This was a case that came out in June of last year where we're talking about best practices here today, where this law firm was dinged by the government, and they were actually forced to implement their own Medicare protocols for their cases. They failed to pay back a lien and got hit by it for not doing it. And Medicare, as part of their deal with the government, said, look, going forward, you've got to establish your own Medicare compliance program. And that's what I'm telling you all today to do, is to get that jump start on establishing your own Medicare compliance program. We can help you do that for no charge. We're happy to do that. We're happy to help you come up with ways to audit your files. We're happy to come educate your clients. We're happy to come to your law firm and do these CLEs on these Medicare set-aside issues and Medicare secondary payer compliance issues. So your staff can be aware of what's happening and can identify these cases so your law firm is protected and your clients are protected. When you're settling your case, you got to determine if future medicals are funded. Number one, if they are, educate your clients on the risks again, and then select the appropriate solution. We oftentimes use the acronym CAD, consult with experts, advise your client about the issues, and document your file, and document your file some more. Ultimately, if we're going to be doing a Medicare set-aside for one of our clients, once the case has resolved, and I want to stress, once the case has resolved, it becomes, how do we eliminate the MSA issue itself? And there are many ways to eliminate the MSA issue without doing a Medicare set-aside. There are a lot of situations where you have a client that's on Medicare benefits that still, given their situation, they don't need to do a Medicare set-aside. And we don't have time to talk. That's a whole other presentation itself. But there are many, many scenarios where you may have a client that's on Medicare and they don't need to do a Medicare set-aside or even consider one. But ultimately, our job becomes, if we're going to do a Medicare set-aside, how do we get the lowest number? 87%. This is a real number based on real facts that we were able to drive down the cost of a Medicare set-aside by on average of 87% last year. What that means is, for example, if we had a $100,000 Medicare set-aside, we were able to get that down to about $13,000. That's a huge, huge savings while being compliant with the statute, while making sure you're protected, while making sure your client's protected. And those are real dollars that go in your client's pocket. The last thing I'll tell you today is please take advantage of free information. You can go on to CMS's website and sign up for automatic alerts. I would encourage you all to do that so you can stay ahead of the issues and be aware of what's happening if anything does come out with Medicare. please take advantage of the resources that you have here at Synergy. We offer those complimentary CLEs, whether it be by web or in person. We're happy to do it either way, where we'll educate you, maybe feed you a nice meal, and you earn CLE credits at the same time. And more importantly, you'll leave those meetings with a fundamental understanding and knowledge of how to protect your law firm. Thank you again for listening to this. I'm going to pass it over now to Evelyn, who's going to be discussing Medicare set-aside trusts.
Good afternoon. My name is Evelyn Pacino, and I'm the Executive Director of Pooled Trust Services. We administer 4 national pooled trusts, and I'm here to talk about 2 of those trusts and how they dovetail with MSAs to help your clients protect their public benefits. So first, I'm going to spend a couple of minutes on public benefits programs. The reason I'm doing this is that whether or not your client has public benefits and what kind of benefits they have is going to determine whether or not they need a trust. So generally, public benefits are going to fall into 2 categories. As you can see here, there are needs-based public benefits and entitlement public benefits. Now, it's important to know the difference between these because needs-based public benefits are income-based, meaning that if your client exceeds certain income or resource limits, they're potentially going to lose those benefits. And because an MSA is considered income, an MSA could potentially disqualify them for those benefits. There are also entitlement public benefits. Now, these are benefits that once a person qualifies for them, income is not going to disqualify them. So in that case, getting a large settlement is not going to disqualify them from SSDI or Medicare or any other entitlement public benefits. Now, it's important to understand the difference because a lot of clients aren't fully aware of what they have. And it's really important to know, whether they have needs-based or entitlement public benefits. So it's a good idea to get them to provide their award letters if they have those on hand and really dig into which benefits they have so that you can help them understand what they need to protect those public benefits. There are also other public benefits programs under Section 8 and veterans benefits. We put these in a separate category because sometimes they're means-based or needs-based and sometimes they're entitlement-based. So again, you just really have to dig into what kind of benefits they are to understand what impact a settlement could have on those benefits. Now, there's a common misconception about, let's start this slide over a little bit. Okay. Now, this is a common misconception, but not every disabled client is going to need a pooled trust. So generally, a trust is going to make the most sense for a client who's disabled, meaning they can no longer work, and they have some kind of public benefits that they need to protect. Now, trusts by nature are going to have restrictions, so it doesn't make sense to apply those restrictions unless they're actually benefiting the client by protecting their public benefits. So what is a pooled trust? So basically, this is a master trust document that multiple people can join. In order to join it, the person is going to sign a joinder, which is basically a contract that creates a sub-account for them within the trust. Now, the main benefit of this is that you're going to be using a trust that already exists, and it already has a team of people behind it who are administering it. So unlike a standalone trust, which is going to require a lot of time and potentially money to draft the trust, to find a trustee who's qualified to serve, joining a pooled trust is as simple as just signing the joinder and funding the trust. Now, these are our 2 MSA pooled trusts. First is the Settlement Solutions National Pools Medicare Set-Aside Special Needs Trust. This trust combines the public benefits protection of a special needs trust with the benefits of professionally administered MSAs. Our other trust is the Settlement Solutions Medicare Set-Aside Pooled Trust. Now, this is more like a settlement trust, but with the professional administration benefits. So to help illustrate the difference between the 2, here are a couple of scenarios that show where it makes sense for different clients to have these kinds of trusts. So if someone is disabled and they have Medicare, then it's going to make sense for them to have the Medicare Set-Aside Pooled Trust. Again, they're not trying to protect any kind of public benefits. So really, they just need professional administration for their MSA. Now, if you have a client who's disabled and they're dual eligible, meaning they have Medicare and Medicaid, then it makes a lot more sense to have the special needs trust combined with the MSA pooled trust. And basically what this means is that they have a special needs trust, so they get all the protection for their needs-based public benefits, but their MSA is structured within it. So as I said earlier, MSAs are considered income, but when they're structured within a special needs trust, they get their protection so they are no longer considered income, which is really important for your clients who have a needs-based benefit like Medicaid or SSI, because if it's within the special needs trust, they aren't going to be disqualified from those benefits. And finally, here's a little bit more information about our MSA pooled trusts. They were established by the Foundation for those with special needs, and the foundation serves as a trustee. The foundation is a 501c3 that does charitable work in the community that supports civil justice. TrueLink Financial is our trust administrator, so they handle the administration of the trust, investment management, those kinds of things. Rising Financial is our MSA administrator, so they do all the bill adjudication, and Optum handles all of the prescription benefits. So when one of your clients joins one of our MSA pooled trusts, they're going to get cards for Rising and Optum, which they're going to give to their providers whenever they need services. So when they go to the pharmacy, they use their Optum card. When they go to the doctor, they use their Rising card. And all that is explained to them when they sign up for the trust, so that there's no confusion about which card to use when. This is a huge advantage over custodial accounts because these trusts can potentially go on into perpetuity, and they have all the legal protection that trusts have, which custodial accounts don't have. So that's a big benefit for clients because there's more protection over their funds. And just to talk a little bit about fees, so there's going to be a one-time fee at inception. It depends on how much is allocated for the MSA, so it could range anywhere from $750 to $5,000, but that's something that would be explained up front. Now, as far as annual fees, most of our clients don't have an annual fee because if their prescription costs are above $25,000, and that considers all prescription costs in the future, they're not going to have a fee, in which most people meet that requirement. If they don't meet that requirement, then they have a $300 annual fee. Now, here's just a summary of all of our other pooled trusts. As I stated, we have 4 pooled trusts that we administer nationally. 2 of them are MSA, as you can see, and then we also have a special needs trust. So for people who don't have a Medicare set aside, but do have other benefits to protect, they can just join the special needs trust. And then we have a settlement protection trust as well that basically just has spend-serve protections and gives the person the benefit of having professional administration and I don't know, I need to start this one over. Okay, back up a little bit. Okay, and finally, here's just a quick summary of the other trusts that we administer. As I mentioned, we have 4 national pooled trusts. In addition to our 2 MSA trusts, which I just discussed, we have a pooled special needs trust. So that's for anyone who has any kind of public benefits but does not have an MSA. And then we have a settlement protection trust, which provides basically just general, spend-serve protections over their funds, and they have the benefit of having a trustee administer those funds, as well as investment management. So if you'd like to learn more, please give us a call at the number on the screen, and we'll be happy to discuss your client's needs.